Okay, perfect. We are all set and the YouTube stream is up and running. So we are ready to begin. Thanks for your patience, everyone. And Judge Holmes, whenever you are ready to start, we are good to go.
Thank you, Ms. Wexler. Good afternoon, ladies and gentlemen. My name is
sorry,
Jeff.
Judge Holmes, can you hold on one second?
Sure.
I'm so sorry about that. We just had one last thing, but Judge Holmes, you are good to go now, and I'm going to turn my screen off and mute myself.
All right, thank you, Ms. Wexler. Good afternoon, everyone. My name is Jeff Holmes. I'm the district court judge who has been assigned to preside over this case. This is the case of People v. Becker. As a preliminary matter, let me ask, is the prosecution ready for trial?
Yes, Your Honor.
And is the defense ready for trial?
Yes, Your Honor.
Some of the things I'm going to request of you are worded a little strangely, perhaps because of the virtual nature of some of this proceeding, as opposed to having you physically present. But let me ask that each side provide myself and the scoring panelists with copies of your trial roster with the team's code. There should be no words, symbols, or other marks that identify the team by its school on that trial roster. And we will have the respective team members identify themselves in a moment. I don't know if there are any video cameras or recorders present and being used, but if so, they are prohibited unless both teams have approved the taping of the round. Coaches and people in the gallery are not permitted to tape the trials without permission. The Colorado Bar Association may be taking photographs of the competition during the round, and team participation in the state tournament grants automatic permission and the use of these photos by the Colorado Bar Association. Anyone who is in the gallery who is connected with teams not competing in this round, student members and coaches of other schools or of the same school but a different team, must leave the courtroom. There are, as you are probably aware, a couple of exceptions to this rule. Teacher coaches may view any team from his or her school. Teacher coaches or attorney coaches, who are the parents of students competing on a team other than the team the teacher or attorney is coaching, may watch his or her child. And any attorney, coach, teacher, sponsor, parent, sibling, or other spectator associated with the school of mock trial team may observe another team's round if they obtain permission from each team participating in that round, and disclose their presence and the team's acceptances to the judge during preliminary matters. Teams are reminded that no recesses will be allowed, with the exception of those granted for a health emergency, and especially not between the end of a witness examination and the beginning of closing arguments. Although there has been a conflict check done, I would ask each scoring panelist if she has any reason to be biased in judging either of these teams. If any panelist is concerned She should notify me, and I will notify the courtroom monitor, the state tournament coordinator, or a mock trial committee member, and arrangements may be made for replacements. Team members may raise an objection regarding a particular scoring panelist at this time as a preliminary matter. The objection is deemed waived if it is not made as a preliminary matter. If there are any objections, please unmute or signify in some way so that the court can address them. But if I don't hear anything or see any suggestion that there is, we will move forward. The teams and coaches are reminded that any disputes arising out of the competition must be reported in accordance with the competition rules. Teams are reminded that their compliance with time requirements will be considered in scoring individual performances. No coach or team member, other than a timekeeper, if a timekeeper is not provided by the competition committee, should be seated in the jury box. Each side at this time will be asked to introduce their participating team members. So if we could begin, please, with the prosecution, and if we could have the introduction of team members.
On behalf of Team Sotomayor, the prosecution, good afternoon, Your Honor, opposing counsel, members of the jury. My name is Abigail Lowe. I will be directing Kyle Kuzak, crossing Professor Blake Van Owen, and presenting the closing argument for the prosecution.
My name is Lindsay Harriman, and today I'll be conducting the opening statement for the prosecution, the direct examination of Detective Jordan Markowitz, and the cross-examination of Taylor Perkins.
My name is Caitlin Duffy. I will be directing Alex Cifuentes, and I will be performing the conduct of Avery Becker. Your Honor, at this time, may our witnesses introduce ourselves?
They may.
My name is Lila Bednar, and I will be portraying Alex Cifuentes.
My name is Robin Kite, and I will be portraying Detective Jordan Markowitz.
My name is Sasha Leitak, and I'll be portraying Kyle Kuzak.
Thank you. And if I could have the defense, please introduce their members.
Good afternoon, Your Honor. My name is Tatum Butler. I represent the defense in this case. I will be direct examining Blake Van Owen, cross-examining Kyle Kuzak, and delivering the closing argument. May my co-counsel be permitted to introduce themselves?
They may.
My name is Eli Kim. I'm direct examining Taylor Perkins, cross-examining Jordan Markowitz, and delivering the opening statement.
My name is Rowan Kennedy, and I will be directing Avery Becker and crossing Alex Cifuentes. May my witnesses introduce themselves?
Yes, please.
Good afternoon, Your Honor. My name is Abby Sears, and I am Avery Becker.
Good afternoon, Your Honor. My name is Logan Piscatello, and I am Taylor Perkins.
Good afternoon, Your Honor. My name is Sophia Weinecht, and I am Blake Van Owen.
Thank you all. At this time, the court does need to administer oaths. Oaths will be administered to the team members, the gallery, the scoring panelists, and the witnesses. Because of the circumstances of this virtual proceeding, I will not require that you stand when taking the oath. However, I do wish to emphasize that all members, all observers are to observe the code of ethical conduct. If I could begin, please, with the team members, and if each of you would please raise your right hands. Team members, Do you promise that the presentation you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition? Please signify by saying, I so swear, I so affirm. Thank you. And while we may have had some of the witnesses because of the description of team members, I'm going to administer a separate oath to the witnesses. So if the witnesses would please raise their right hands. And witnesses, do you promise that the testimony you are about to give will faithfully and truthfully conform to your witness statements, that you will not add material facts or opinions which are not contained in the case problem, and that you will follow the rules and procedures of the mock trial competition? Please signify by saying, I will or I so affirm. Thank you. Gallery members, this includes teachers and attorney coaches, family members and friends. Please raise your right hands. Do you promise to represent yourselves as positive role models and to behave in a manner that exemplifies ethical and professional sportsmanship during and after this mock trial round? Please signify by saying, I will or I so affirm. And finally, scoring panels, if you would please raise your right hands. Do you promise to adjudicate the mock trial competition as fairly and objectively as possible in accordance with the facts, procedures, and rules of the mock trial competition? So please signify by saying I will or I so affirm.
I will.
Thank you. At this time, then, we will begin with opening statements.
Your Honor, I apologize for interrupting, but the prosecution has some preliminary matters to discuss.
That would be just fine. Thank you, Ms. Duffy.
Permission for the exhibits to be constructively published to the jury only after their admissions.
Yes.
And permission for time to be paused should any technical difficulties arise.
Yes, I would anticipate that being the right way to proceed. I guess it kind of depends a little bit upon what the problem is. But we'll certainly try to make sure that adequate time is afforded if there is a technical glitch.
And permission for remaining time to be used for rebuttal.
At the conclusion of your closing argument, you mean? At the time of the rebuttal closing?
Yes, Your Honor.
Yes, I will grant that. I'll grant it for both sides. Well, I'm sorry, I'll grant it for the prosecution. If there's any time remaining as far as a particular portion of the proceedings regarding a witness, then that is lost. So understood.
And the prosecution also asked that all these privileges be granted to the defense.
Yes, they will be.
No further preliminary matters, Your Honor. Thank you.
Did the defense have any preliminary matters?
Yes, Your Honor. Defense moves to enter the stipulations into evidence.
The stipulations will be received. I think now with those preliminary matters addressed, we can have prosecution's opening statement.
Taking that one step too far can escalate a situation to a point of broken ties with mentors and friends. Taking another step too far can escalate a situation to a point of disaster and tragedy. Friday, March 6th, 2020 began normally enough. We could feel springtime approaching as we looked forward to the time we would spend relaxing and recovering over the weekend. Mackenzie Brackman started his weekend early. Having that Friday off, Mr. Brackman had spent the morning quietly in his home. Mackenzie Brackman had dedicated his life to the law. Not only was Mackenzie Brackman a successful criminal defense lawyer, he also coached a team of young students in Colorado High School's mock trial club. Mr. Brackman couldn't have anticipated that his life was about to be stolen. At approximately 1:05 p.m., an intruder walks past Mackenzie Brackman's security cameras and into his backyard. The intruder steps into Mr. Brackman's home through the back door. Inside, the intruder startles Mackenzie Brackman. Scared and confused by the intruder in his home, Mackenzie Brackman grabs a knife from his kitchen and hopes of fending off the intruder. The intruder is relentless. Brackman loses the knife to the intruder. Now in possession of the knife, the intruder becomes a killer, stabbing Mackenzie Brackman in his shoulder. The killer immediately escapes, fleeing Mr. Brackman's residence. Mr. Brackman, in pain and bearing a fatal stab wound, makes his way to his front door. There, he pulls the knife out of his shoulder and begins to bleed. Mr. Brackman, a man who had dedicated his life to the law, took his last breath in the doorway of his own home. He bled to death, and he did not get to say goodbye to his students or his family. Today, Mr. Brackman's killer sits before you. The police concluded that Avery Becker, a student on the Colorado High School mock trial team, broke into Mackenzie Brackman's home. Avery Becker is on trial for the burglary and murder I just described to you. Becker is charged with burglary and felony murder. In the previous months, the defendant had battled with Coach Brackman about her lackadaisical attitude towards mock trial. Unrelenting in nature, the defendant continued to disagree with her coach. You will learn that after facing criticism about her work ethic from Mr. Brackman, the defendant retaliated against him, taking her hatred for her coach a step too far and vandalizing his vehicle and permanent marker. Mr. Brackman decided to remove the defendant from his mock trial team. This angered the defendant. The defendant took her hatred for Mackenzie Brackman a step even further. The evidence shows that the defendant broke into her coach's home with the intent to vandalize it, like she had vandalized the vehicle. After being caught off guard by Mr. Brackman, the defendant took a leap too far. In today's trial, you will hear from a homicide detective of 7 years, Detective Jordan Markowitz, and a crime scene investigator of 19 years, Kyle Kuzak. Detective Markowitz confirmed the defendant's location at the date and time of the crime by obtaining detailed records of incoming calls to the defendant's phone and drawing a map that depicts the progression of the defendant's location. Kyle Kuzak analyzed the evidence matching the events of Mackenzie Brackman's murder. Colorado High School student and mock trial member Alex Cifuentes observed the defendant's disgruntled association with Mackenzie Brackman, her coach. Ms. Cifuentes witnessed each time the defendant took a step too far in her retaliations against Mr. Brackman's criticisms. We, the prosecution, have the burden of proof. This means that after considering all of the evidence presented throughout this trial, you, the jury, will decide whether we have proved the defendant's guilt beyond any reasonable doubt. We will show you that the defendant committed first-degree murder and second-degree burglary. When making your decision, we ask you to consider a distinction between mere claims and hard evidence. After listening to the evidence and witnesses presented in this case, we, the prosecution, will ask you to prevent the defendant from taking another step too far. The hard evidence gathered in this investigation proves the defendant guilty of her crimes. Please convict the defendant of murder in the first degree and burglary in the second degree.
Thank you, Ms. Harriman. Defense counsel, would you like to make an opening statement?
Yes, Your Honor.
You may do so.
Your Honor, members of the jury, may it please the court. My name is Eli Kim, and Mackenzie Brackman was tragically murdered in his own home. The defendant, an innocent teenage student named Avery Becker, has been falsely accused of committing this murder. Members of the jury, this case is a result of a botched investigation. The prosecution's evidence is unreliable due to the incomplete and inadequate jobs of Kyle Kuzak and Jordan Markowitz in this investigation. These so-called experts were not completely thorough, and various faults can be seen in their methods from this investigation. There's evidence that will be heard today that will give you doubt about Avery's role in this case, and there should be. This doubt should drive you to believe the truth, which is that she was not guilty of this murder, and because of the insufficient jobs of the experts that were assigned this investigation, there's no way of proving her guilt. From our three witnesses, you'll hear how 1, Avery was nowhere near Brackman's house the day of the murder and did not have any intentions of killing Brackman. You will also hear about the jealous, twisted intentions of a fellow student by the name of Alex Cifuentes. 2, Taylor Perkins, Avery's best friend, testifying that she was with Avery the length of March 6th to look for her lost phone. 3, Blake Van Owen, an expert in police practices, proved Kyle Kuzak and Jordan Markowitz to have botched this investigation, and how this case is a result of an investigation gone wrong, not a burglary gone wrong. There's plenty of evidence that proves how Becker could not have committed this murder, and plenty of evidence that proves that there is no way of proving her guilt. In today's case, you'll first directly hear from Avery Becker about her relationship with Brackman and how she had no intentions of ever killing him. You'll hear about how even though she vandalized his car, she felt horrible about it and did everything in her power to fix what she had done. These are not the actions of a murderer. How could she possibly, after how much this vandalism ate her up internally, go on and kill the person for whom she felt sorry? You'll hear about how she was with her friend Taylor Perkins the whole day on March 6th, the day of the murder, and how she was nowhere near Brackman's property. You'll hear about her mock trial teammate, an envious student by the name of Alex Cifuentes, who is always jealous of Avery's mock trial skills and how his motives aligned with harming Becker's reputation to boost his own. Second, you'll hear from Taylor Perkins, Avery Becker's best friend, explaining how there is no possible way that Avery could have committed this murder. She'll explain how she was with Avery the whole day on March 5th and 6th and how they were searching for Avery's lost phone on the day of the murder. She'll tell you that they were nowhere near Brackman's house. Finally, you'll hear from an expert witness in police practices, Blake Van Owen, explain how this case is truly a result of an investigation gone wrong, not a burglary gone wrong. He'll tell you about the flawed methods of Jordan Markowitz and Kyle Kuzak. You'll see how this investigation was incomplete. You'll see how the police took the easy way out. He'll show you how the police department had already made assumptions before the investigation. He'll tell you about Jordan Markowitz taking screenshots of important evidence instead of seeing it in person himself. You'll see that this was a failed investigation and that the evidence is flawed. The truth that will emerge today is that there is no way of proving that Avery Becker was the one who killed Brackman. The evidence will show that there's no way of identifying the intruder of Brackman's property and that Avery Becker was with Taylor Perkins the whole day on March 6th. This false accusation that Avery Becker was the one who killed Mackenzie Brackman is a result of a failed investigation. The so-called experts who investigated the crime scene did a poor job in carrying out this investigation, and therefore their conclusions should not be relied upon to accuse anybody of this murder. Members of the jury, as you learn about the location of Avery Becker on March 6th, the envy of Alex Cifuentes, and the investigation itself, it will become clear that Avery Becker is truly innocent. At the end of this case, we will ask you to return a verdict of not guilty.
Thank you, Mr. Kim. The prosecution's first witness, please.
Your Honor, the prosecution calls Alex Cifuentes to the stand. Ms. Cifuentes, please state your name and spell your last name for the record.
My name is Alex Cifuentes, Sifuentes.
How would you describe your association with Avery?
Well, Avery and I were best friends and also fellow teammates in mock trial.
Who was Mr. Brackman?
Coach Brackman was our amazingly talented mock trial coach, and he was also a local defense attorney in addition to that.
What did you observe about Avery's and Coach Brackman's interactions in mock trial?
Well, Avery and Coach Brackman did not seem to get along very well from what I could see. Just constant arguing, disagreeing about how, what constituted a good student in mock trial, so lots of conflict there.
And what qualities and habits did Coach Brackman stress in mock trial?
Coach Brackman always stressed the importance of proper preparation and overall just taking the mock trial as a club very seriously.
And what was Avery's work ethic like?
Avery's work ethic was not really what Coach Brackman would have liked at all. Avery was always coming late to practice, improvising everything, and not taking it really all that seriously.
And what roles or characters did they portray in mock trial?
Avery portrayed a lot of attorneys, but was also a very talented witness as well. Really, she could make you believe anything on the stand.
And how did Avery react to Brackman's feedback after regionals?
After regionals, Coach Brackman and Avery got in a pretty bad argument, and it escalated with Avery leaving pretty quickly out of the meeting.
And how did Avery getting kicked off the mock trial team affect the mock trial team?
It affected the mock trial team in a lot of ways. Most notably, we would have had to forfeit going to state, which was pretty unfair to everybody on the team.
Did Avery contact you after they got kicked off the team?
Yes, Avery sent me some text messages asking if I could talk to Coach Brackman about having her back on the team.
Your Honor, permission for the witness to view Exhibit 14?
Yes.
Let the record reflect that my co-counsel is showing the witness what has been previously marked as Exhibit 14. I apologize, we're having some technical difficulties. Do you recognize Exhibit 14, Ms. Cifuentes?
Yes, these are the screenshots I was just talking about.
What is Exhibit 14?
These are the text messages that, screenshots of the text messages that were exchanged between Avery and I.
How do you know?
Because I had received them and I had also replied to them as well.
And is Exhibit 14 a complete and accurate copy of the text messages exchanged between you and the defendant?
Yes.
Your Honor, I move to admit Exhibit 14 into evidence.
What is the defense's position regarding Exhibit 14?
No objections, Your Honor.
14 is received.
Ms. Cifuentes, what did Avery ask you over text?
Avery asked me, is there any way you'd be willing to talk to Coach Brackman about having me back in reference to getting back onto the team?
And how did you respond to Avery with this?
I respond with, I didn't know, because Coach Brackman was still pretty upset with her at the time, and I said I would try to anyway.
How did the defendant respond to this?
After I said that, Avery replies with, well, if he's still upset about his car, then he's going to be really upset when he sees what I do to his house.
Why were you willing to talk to Brackman on letting Avery back on the team?
Because the team was in a pretty tough spot because of what happened with Avery. And overall, I just wanted everybody on the team to, have a fair shot to go to state.
Let the record reflect that my co-counsel has stopped sharing their screen. Did anyone reach out to you in regards to these text messages?
Yes, I was talked to by a police detective, Detective Markowitz, who had asked about my involvement, and I just gave him the screenshots.
And why did you feel the need to come forward about these screenshots?
I came forward because, the last thing I would ever want to do is rat out my best friend to the police, but that was sort of the right thing to do considering what the screenshots contained.
No further questions, Your Honor.
Cross-examination.
Ms. Cifuentes, you were on the mock trial team with Avery Becker and Taylor Perkins, correct?
Yes, I was.
In fact, you said you're basically best friends with Avery Becker, correct?
Yes, I was best friends with Avery Becker.
And you thought very highly of your mock trial coach, Mackenzie Brackman, right?
Of course, Coach Brackman was very talented as a lawyer, in addition to being a coach.
Avery always got the recognition on a mock trial team, didn't she?
Well, that was true. Avery was certainly talented at some aspects of mock trial. She was very good at improvising, certainly.
Avery also was late and never prepared for mock trial.
Yes, that is very true.
But you worked very hard for mock trial, didn't you?
Yeah, I spent a lot of effort on mock trial.
Yeah, Avery received all the recognition and even got the Best Attorney Award, correct?
Yes, as I said before, Avery was certainly talented at improvising.
And also, the mock trial students sometimes went to the Fry Shack after mock meetings, correct?
Yeah, yes.
And you went to the Fry Shack the day Avery was kicked off the team, right?
Yeah, the whole mock trial team was there too.
And you did speak to Avery at the Fry Shack, right?
Yes, briefly.
And you also had Avery's phone in your possession the day before the murder, correct?
Briefly, I did. We just were having this great conversation about how Avery should move forward for mock trial. And at that point, she let me play some games on her phone for a minute.
And for the investigation, a detective did ask you to see your phone, right?
Yes.
And you didn't have it with you when you went to see the detective.
I didn't have it with me when I went to see the detective, but I did send the screenshots of the text messages the day after, so.
And you were jealous and annoyed of Avery Becker and her mock trial role on the team, weren't you?
Well, Avery was certainly, like I said before, talented at some aspects of mock trial, but just wasn't really working as hard as some other people on the team.
Okay, no further questions, Your Honor.
Redirect examination.
Yes, Your Honor. Who convinced you to join the mock trial team, Miss Cifuentes?
Avery did when I was a freshman.
No further questions, Your Honor.
Is there any recross examination?
No, Your Honor.
Thank you for your testimony. The next witness for the prosecution, please.
Your Honor, at this time, the prosecution calls Detective Jordan Markowitz to the stand. Good afternoon. Please state your name and spell your last for the record.
Good afternoon. My name is Jordan Markowitz, and that's Markowitz.
Let's start by having you tell the jury a bit more about yourself, Detective Markowitz. What do you do for a living?
I'm a detective. I work for the Denver Police Department, and I've been working with them as a detective for 7 years now, although I started my career at the DPD about 13 years ago.
Why are you testifying today?
Well, on March 6th of 2020, I was assigned to investigate the death of a Mackenzie Brackman, who was a criminal defense attorney as well as the coach for the Colorado High School mock trial team.
What specialized training have you received?
I have specialized training with cell phones. Specifically, I'm certified by the American Academy of Law Enforcement in cell phone technology and forensic data recovery. In order to receive that certification, I had to take a training course, and then after that, I also had to pass a certification test.
How often do you use that training?
In my job as a detective, I use that training all of the time. I've downloaded the contents of hundreds of phones at this point, and I've also gathered and analyzed the cell tower data in over 50 cases.
Your Honor, at this time, I move to tender Detective Jordan Markowitz as an expert in crime scene investigation and forensic data recovery on the grounds of her experience and training.
Defense position regarding that proffer.
No objection, Your Honor.
The witness will be qualified as an expert in the areas described and permitted to give opinion testimony.
Let's talk about the defendant. How did you first learn of the defendant?
Well, I learned about the defendant after I learned about the victim, Mr. Brackman's relationship with mock trial, working as the coach for CHS. And once I learned about that relationship, which I learned about First of all, because he was wearing a mock trial shirt when we found him. And second of all, after I downloaded the contents of his phone, mock trial was mentioned everywhere. But once I learned about that relationship, I thought it would be reasonable to investigate it. So I contacted Colorado High School. I had them give me the phone numbers of all of the students on the team. And from there, one of the students that I contacted, Alex Cifuentes, told me about the defendant, as well as some concerning text messages that they had received from her.
What interviews did you conduct throughout this case?
Well, I conducted an interview with Alex Cifuentes, and once I learned about Avery Becker, I also invited her to an interview, and she was going to oblige, but unfortunately, right before the interview, her attorney reached out to me and said that she would no longer be in contact with me whatsoever.
Your Honor, permission for my co-counsel to share their screen with Exhibit 14, which has previously been admitted into evidence.
She may.
Detective Markowitz, will you please read the defendant's last two text messages aloud for us?
Sure. Well, if he's still upset about his car, then he's going to be really upset when he sees what I do to his house. I'm going to wait until he's at work, then break in and trash it. These are the concerning text messages I got from Alex Cifuentes.
Let the record reflect that I have that my co-counsel has stopped sharing Exhibit 14. Let's talk about what you observed on the scene of Mr. Brackman's murder. How did Mr. Brackman look upon your arrival at the scene?
Well, Mr. Brackman was located in the front door area. He was face down. He had a stab wound in his upper left back and shoulder area. It was blood-soaked, and nearby there was a knife.
What did you observe about Mr. Brackman's kitchen?
Well, the first thing that I noticed about the kitchen was that it was in a general disarray, but really there were two important things to note about what I saw in the kitchen, which is that, one, there was a knife slot, like a knife block, pardon me, and one of the slots was empty, so there was a missing knife. And there was also in a jar drawer that had a large variety of different kinds of knives in it.
What did you see outside of Mr. Brackman's home?
I immediately noticed when I was walking around the perimeter that Mr. Brackman had a Ring doorbell set up, which is like a security system. So after that, I went around the rest of the perimeter to see if he had any other set up. And he did. He had one set up facing the back gate as well as one facing the back door.
Detective Markowitz, are you familiar with Exhibits 10, 11, 12, and 13?
I am. Those are the exhibits that contain the videos of the intruder on that day of March 6, 2020. And I got those because I downloaded the contents of Mr. Brackman's phone, which allowed me to access his Ring account.
To your knowledge, have copies of Exhibits 10, 11, 12, and 13 been provided to opposing counsel?
Yes, they have.
Are these exhibits accurate copies of the Ring security footage you obtained from the scene of the crime?
They are.
Your Honor, at this time, I move to admit Exhibits 10, 11, 12, and 13 into evidence.
Defense position regarding Exhibits 10, 11, 12, and 13.
No objection.
All four exhibits are received.
Your Honor, permission to share my screen with these exhibits?
You may.
Detective Markowitz, will you please describe what's happening in Exhibits 10 through 13 as they play on your screen?
So this is the view from the Ring doorbell, which is outside the front door. We see a masked intruder wearing a hoodie and gloves coming up. You can hear them trying to open the front door, but upon realizing it's locked, they go around the back. This is the view of the back gate. And we see that same masked intruder entering in. And this is the view of the back door. The intruder opens it upon finding it's unlocked and goes in. Then this video was a little while after, and we see the intruder sprinting out the front door.
Let the record reflect that I have stopped sharing my screen. Let's discuss the connection you made between the crime scene and the defendant. After receiving the screenshots and the defendant's refusal to be interviewed, what did you do?
Well, naturally, I went and I obtained a search warrant for Avery Becker's phone. But after I obtained it, I was informed by Avery Becker's attorney that Avery did not have her phone. So I was, however, provided with Avery's phone number, and using that, I was able to obtain the call detail records for Avery's phone for March 6th.
What are call detail records?
Call detail records are basically records of communication between a phone and a specific antenna of a cell tower. And it records what kind of communication it is and at what time that communication occurred. And it lets us essentially track where the phone is by being able to see which cell towers and which antennas it connected to.
What did the defendant's phone's call detail records show?
Well, the defendant's call detail records showed us that on March 6th of 2020, Avery was at first at home and then moving towards Mr. Brackman's house, and then she was in Mr. Brackman's house.
Your Honor, permission for my co-counsel to share her screen with Exhibit 15?
She may.
Let the record reflect that my co-counsel is now sharing her screen. Detective Markowitz, do you recognize Exhibit 15?
I do. This is a diagram that I made to represent the movement of the defendant's phone on the day of March 6th.
Is this a fair and accurate representation of Exhibit 15?
Yes, it is.
Your Honor, I move to admit Exhibit 15 into evidence.
Defense position regarding Exhibit 15.
No objection, Your Honor.
15 is received.
Detective, in summary, what do the call detail records indicate?
Well, these red areas are the antennas that the defendant the defendant's phone communicated with. So we see that Avery Becker was at home around 12:47 and then left and started driving towards Mr. Brackman's house at around 12:55. And then per the call detail records, the defendant was present at Mr. Brackman's house from 1:05 to 1:17 p.m.
Let the record reflect that my co-counsel has stopped sharing Exhibit 15. Let's talk about your conclusion as an investigator in this case. How have you reached your conclusions?
Well, all of my conclusions are based upon me following where the evidence leads me, as well as the specialized experience that I have and the general detective experience that I have.
What final conclusion did you reach as an investigator in this case?
Well, based on all of the evidence that I gathered, that my team gathered, that Kyle Kuzak gathered, it's clear that Avery Becker, after getting kicked off of the mock trial team by Mr. Brackman because she vandalized his car, she then planned to vandalize his house when he wasn't home. But unfortunately for Mr. Brackman, he was home. He was notified to Avery's presence by his Ring security system. So he armed himself with a knife from his kitchen. But when Avery went in through the open back door, Avery was able to maintain or was able to gain control of the knife and stab Mr. Brackman in his shoulder before fleeing the scene.
No further questions, Your Honor.
Cross-examination.
Yes. Detective Markowitz, the first person you interviewed was Alex Fuentes, correct?
That's correct.
Alex Fuentes did not bring his phone to the interview, correct?
Alex Fuentes did not bring her phone to that interview, no.
You dismissed this dismiss this despite knowing that the main piece of evidence given by Fuentes was on the phone, correct?
I didn't dismiss it. I had Alex send me the screenshots the next day.
You are aware of the possibility of him manipulating the text, correct?
I do not believe there is any possibility she manipulated the text messages. Otherwise, I would have had her bring her phone in, which she did offer to do, but since we had the screenshots, it wasn't necessary.
You are aware that Becker said that she lost her phone the day before the murder, correct?
That's correct. That's the reason I was given for not being able to search her phone.
You never followed up to locate Cifuentes' phone either?
I'm sorry, I don't understand the question.
Did you ever follow up to locate Cifuentes' phone?
We never lost location of Alex Cifuentes' phone. Like I said, she did offer to bring it in that very next day, but it wasn't necessary since we could just have her send us the screenshots.
Okay. Detective, please refer to exhibits 10, 11, 12, and 13. Do you recall these exhibits?
Yes, I just spoke about these. These are the ring security videos.
Okay. So in these videos, you can't tell how tall the perpetrator is, correct?
Well, we're able to give an estimate of how tall the perpetrator is, and one of the things that we noted is that the intruder is actually about the same height as Avery Becker.
But you can't identify the gender of the perpetrator, correct?
The perpetrator is wearing a mask, so no.
You can't see the face of the perpetrator?
No, and I would like to make it clear that the ring videos are not the only thing that led us to Avery Becker. That was from the call detail records and the screenshots.
You can't see if the assailant is carrying the weapon, correct?
No, we do not see any weapon on the intruder, which is why another part of the reason why we believe that Mr. Brackman armed himself with a knife from his kitchen and then the intruder gained control of it.
So can you be 100% of the perpetrator's identity?
So as I said when I was making it clear earlier, the ring videos, it's a masked intruder, but we can identify that intruder through the call detail records and through the screenshots.
Based on the ring videos, can you be 100% of the perpetrator's identity?
If you're just looking at the ring videos, you can't see their face, so no.
No further questions, Your Honor.
Redirect examination.
Yes, Your Honor. Detective Markowitz, let's briefly discuss your investigation. As an investigator in this case, to whom did the evidence lead you?
All of the evidence led us to Avery Becker.
No further questions, Your Honor.
Any recross examination?
No, Your Honor.
Thank you for your testimony. The prosecution's next witness, please.
Your Honor, before I begin, may I ask for a brief time check?
Yes, you do have approximately 6 minutes left.
Okay. Good afternoon, Ms. Kuzak. Please state your name and spell your last for the record.
My name is Kyle Kuzak, K-U-Z-A-K.
What's your relation to this case?
I was the crime scene reconstruction investigator for this case.
What's your profession?
I am a Colorado Bureau of Investigation certified crime scene reconstruction investigator.
How long have you been a crime scene reconstruction investigator?
19 years.
What do you do as a crime scene reconstruction investigator?
I investigate complex crime scenes such as home invasions, burglaries, armed robberies, homicides, things of that nature.
Where are you employed as a crime scene reconstruction investigator?
The last 3 years of my tenure have been with the city of Denver. I'm a civilian employee of the Denver Police Department.
What special licenses or certifications do you have in the scene my apologies, in the field of crime scene reconstruction investigation?
I had to become certified to become a crime scene reconstruction investigator.
Your Honor, at this time, I move to tender Kyle Kuzak as an expert in crime scene reconstruction investigation on the grounds of experience and knowledge.
defendant's position regarding that proffered expertise?
Defense requests to perform a brief voir dire.
You may.
Ms. Cusack, is it true that in your witness statement, you failed to mention any higher education or any education at all, for that matter, that you have?
I did not mention any education in my witness statement, but I can now if you'd like me to.
Not this time. Your Honor, defense objects to Ms. Cusack being entered as an expert in her field per a lack of education.
Any response from the people?
Yes, Your Honor. Under Rule 702, it does not require that the witness being entered as an expert has to have all experience, knowledge, and education. It is an or statement, meaning that I am not entering this witness as an expert in crime scene reconstruction investigation on the grounds of education, but on the grounds of experience and knowledge.
I will overrule the objection. I will allow the witness to testify within the proposed field of expertise, but I will allow the counsel to ask any further questions that may be appropriate and make appropriate argument regarding the weight the witness should receive. You may continue.
Ms. Cusack, how do you carry out crime scene reconstruction investigation?
Well, I'm guided by two key principles. First, I assume every case is going to trial, so I conduct a thorough investigation accordingly. Second, starting from day one, I document, memorialize, and organize all the evidence with a mindset of future reconstruction.
What hands-on investigation did you do in this case, if any?
I visited the scene of the crime, Brackman's residence.
And my apologies. Why did you visit the scene of the crime, Brackman's residence?
Well, visiting the scene of the crime and being able to observe the evidence for yourself allows you to have a deeper degree of understanding, one you wouldn't normally possess by just reading a report.
On the note of evidence, what evidence did you find in your investigation of this murder?
Well, there were the Ring security camera videos, scuff marks on the kitchen floor, a broken kitchen plate, a knife block with a missing knife slot, an open knife drawer, blood splatter, as well as blood droplets, and the knife used in the murder itself.
What were the origins of this knife used in the murder?
Well, as I said, there was a knife block with a missing knife slot and an open knife drawer. It could have come from either of these two places, but most likely being the knife block because the missing knife slot had the same dimensions as the knife recovered in the crime.
What did the broken plate and scuff marks suggest?
They indicated a struggle between the victim and the intruder. As the intruder enters Brackman's residence through the back door, they engage in a close combat struggle. This struggle causes the scuff marks on the kitchen floor, and as they continue to struggle, they go to the kitchen table and bump a kitchen plate off it, causing it to break.
On the note of this altercation, in your expert opinion, what events occurred in this altercation between the defendant and Mr. Brackman?
Well, as the two continue to struggle, the intruder restrains Brackman in a bear hug-like fashion. Then the intruder stabs Brackman. After that, the intruder flees through the front door, as seen in the Ring security camera video. After this, Brackman makes his way from the kitchen table to the front door and pulls the knife out, causing blood cast off on the wall. Then he bleeds out, collapses, and dies.
Have you read or been aware of any other reports in this case?
I have been aware of other reports and an alternate theory, the alternate theory being that Brackman was stabbed at the kitchen table while he was seated.
Do you agree with this alternate theory?
No, I dismiss the likelihood of this theory because first, Brackman would have had to been surprised by the intruder. This wasn't the case. Brackman was either alerted to the intruder by Ring security notifications on his phone or by hearing the back door slide open and hear the intruder walk through the kitchen. Secondly, the intruder would have to have been standing directly over Brackman and would have been holding the knife in a manner opposite the way just about everybody would have held a knife. So these events are highly unusual, and that's why I dismiss this fact.
How would you come to this conclusion in the alternate interpretation of the evidence?
I believe one can only come to this conclusion by having a predetermined outcome while reviewing the evidence.
Thank you, Ms. Kuzak. No further questions, Your Honor.
Cross-examination.
Ms. Kuzak, you mentioned that some of the files at the crime scene were corrupted, correct?
Yes, photos of the blood splatter and droplets became corrupted and lost.
Isn't it true that everything you conclude about this crime is merely a hypothesis?
I mean, I wouldn't say that. After reviewing all the evidence and visiting the scene of the crime, I would say it's a hypothesis, but it's pretty much what happened. I mean, I've been doing my job for 19 years and I follow discrete methods that I do every single time I conduct a crime scene investigation.
You admit that there wasn't as much physical evidence as you would have preferred this crime scene to have, correct?
No, there wasn't as much physical evidence as I would have liked, but that's true for every case. More physical evidence allows me to have a clearer understanding of all the evidence and what exactly happened. But with the evidence provided, and after reviewing all of it, I was able to come to a pretty set conclusion.
You mentioned that the victim would have been alluded to the presence of the intruder due to Ring cameras, correct?
Yes, the intruder could have been notified Mr. Brackman could have been notified either through his cell phone or by hearing the intruder enter through his back door.
But you never mentioned any evidence that the victim got those notifications, is that correct?
Well, I have not previously given a statement on this, but I can now if you'd like me to.
Not at this time. Did you state earlier in your statement that the events and evidence at issue in this case did not indicate a terribly complicated fact pattern?
No, it did not.
But isn't it true that despite this, you were unable to produce a complete reconstruction?
No, I was able to produce a complete reconstruction.
Your Honor, I would like permission to screen share the witness's statement that was given prior to this trial.
Objection, Your Honor, improper impeachment.
I'll overrule the objection. You may do so.
Sorry, I'm having a moment of technical difficulties. Is that visible?
No, I cannot see my affidavit on the screen if that's what you're asking.
Is that better?
Now I'm able to.
Okay. I'm going to scroll to page 24. And if you will just follow along as I read line 130, I was not able to recreate all event segments.
Objection, Your Honor. Improper impeachment. Opposing counsel never verified with the witness that this is their witness statement.
I'll sustain the objection.
I apologize. Do you recall giving a statement before this trial, Ms. Kuzak?
Yes, I do.
And in that statement, you were under oath, correct?
Yes.
You swore to tell the truth?
Yes.
And did you tell the truth?
Yes, I did.
This is a copy of the sworn statement you gave prior to trial, correct?
Yes.
And this is your signature on the page here?
Yes.
And you made this sworn and signed document before a notary public who also signed this document?
Yes.
Please follow along as I read line 130. I was not able to recreate all event segments or place all the evidence, even though it seemed like a straightforward home investigation crime.
Yes, I said that, but that being not being able to recreate all event segments or place all the evidence doesn't mean that I wasn't able to have a full reconstruction report. I reported, I had my full reconstruction report. I used my 5 steps to complete this process, and my reconstruction was peer reviewed by others before it was officialized. So not being able to recreate all event segments isn't consistent with not being able to reconstruct the crime scene fully.
Understood. I will continue with questions then. Is there any way to be entirely sure that the scuff marks found by the back door came from a struggle?
There's no way to make 100% that these scuff marks came from the struggle. It's a possibility that they didn't, but it's not the most likely outcome. If you look at the Ring security camera videos, you'll see that the intruder has black shoes with thick soles. These shoes are most likely would have made scuff marks, especially in a close combat struggle.
Is there any way to know for sure that the broken plate came from a close combat struggle? Excuse me.
Again, there's a possibility that it didn't come from that, but it's not the most likely outcome. Again, there was a struggle between the victim and the intruder, and this caused the plate to be knocked off the kitchen table and shattered.
No further questions, Your Honor.
Redirect examination.
Before I begin, may I ask for a brief time check?
Yes, you do have approximately 2.5 minutes left.
Understood. Ms. Cusack, how did you come to your conclusions in this case?
Well, I followed my 5 steps that I use for every investigation and reconstruction I do.
And when were the blood splatter evidence? When was the blood splatter evidence lost?
They were lost well after my review. I was able to incorporate them in my formal analysis and final reconstruction just fine.
And what did you base your conclusions off of?
I based my conclusions off of all of the evidence that I've observed and I've been given. It's all of the evidence led me to exactly Avery Becker being the murderer.
No further questions, Your Honor.
Recross-examination.
No, Your Honor.
Thank you for your testimony. The defense's first witness, please.
Your Honor, I would like to bring Avery Becker to the stand. Ms. Becker, could you please state your name and spell your last name to the court, please?
Yes, Avery Becker, Becker.
Where did you go to school last year?
I went to Colorado High School.
How long have you participated in the mock trial team?
I was there all 4 years.
And what was your relationship like with your mock trial coach, Mackenzie Brackman?
Our relationship was on bad terms. Brackman thought I was lazy and didn't put in enough work.
Who was Taylor Perkins?
Taylor Perkins was my best friend.
Was Alex Cifuentes also on the mock trial team?
Yes.
What was your relationship like with Alex?
We participated in mock trial, but we weren't friends or anything.
Was there an incident during mock trial practice prior to the crime with you and Brackman?
Yes.
Can you please tell us what happened?
Yes. So Brackman was mad that I came in late for a personal reason, and so he demoted me to B team. Taylor Perkins, my best friend, thought I deserved to be on A team, and so she willingly gave up her spot for me so I could get back on A team. Then I eventually got permanently kicked off the team.
And was there another incident involving Brackman's car?
Yes.
And could you please explain what happened at that incident?
Yes. So Brackman was mad that at regionals I went off script and improvised. And so he kicked me off the team, and I was mad in the moment, and I grabbed a marker and I wrote on his car Worst Attorney Award.
And did you know that marker was permanent?
No, I thought it was Expo.
And after the meeting, what did you say to your mom?
I told her I would get back at Brackman if it was the last thing I did.
Could you please explain what you meant by this?
Yeah, I meant that I wanted to show that Brackman made a mistake, and I wanted to prove Brackman wrong and show that I could be a good mock trial teammate.
What happened the next day after the meeting?
I tried to talk to Brackman multiple times, but he wouldn't talk to me. I wanted to apologize to him, but he wouldn't talk to me. And I sent him a text saying how sorry I was, and I even offered to get a summer job to pay for the damage.
Did you have your phone on March 6th?
No, I did not. I lost it the day before.
When was the last time you saw your phone?
The last time I saw my phone was at the Fry Shack the day before.
Who was there?
Alex Cifuentes and other mock trial people.
What were you doing on March 6th, the day Brackman was killed?
On March 6th, I was retracing my steps and trying to find my phone that I lost the day before.
Who was there?
I was with my best friend, Taylor Perkins.
And did you kill Mr. Brackman?
No, I did not.
Objection argumentative.
Response?
Sorry. No further questions then, Your Honor.
Very well. Did you? I'm sorry. I'm a little concerned that maybe my voice isn't coming through. Did you have any response to the objection that was made?
Oh, I'm
What
sorry.
would you like to say?
So, you were at the mall the day Brackman was killed, correct?
Yes, that's correct.
No further questions.
Cross-examination.
Yes, Your Honor. You testified today on direct that you were at the mall the day Mr. Brackman was murdered?
Yes, I was looking for the phone that I lost.
Okay. And you had a rocky relationship with Brackman?
Yes, our relationship was on bad terms.
And you were often angry with Mr. Brackman?
Yes, that's correct.
In fact, Mr. Brackman hated you.
He thought I didn't put in enough work, and he thought I was lazy.
Miss Becker, is that a yes or no to Mr. Brackman hated you?
Yes, that's correct.
Okay. And you left practice angry one afternoon after an intense dispute with Brackman during mock trial, correct?
Yes, that's correct.
And you wrote worst attorney award in permanent marker on Brackman's car when you stormed out of practice, correct?
I thought the marker was Expo, but yes, that's correct.
And you knew Brackman loved his Porsche before this incident.
Yes, that's correct.
And you had the marker in your hand before you stormed out of the room.
Yes, that's correct.
And your initial plan was to write on the whiteboard with permanent marker?
I don't know why the permanent marker was left on the board, but it was there and I picked it up.
Miss Becker, that wasn't my question. My question was your initial plan was to write on the whiteboard with this permanent marker, correct?
Yes, that's correct.
And after you got kicked off the team, you told your mom, I would get back at him if it was the last thing I did.
I wanted to prove Brackman wrong and show that he made a mistake by kicking me off the team.
Miss Becker, this is a yes to my question that you said I would get back at him if it was the last thing I did when you got kicked off the team, correct?
Yes.
And the first emotion you felt when Coach Brackman kicked you off the team was anger.
My emotions were mixed that day. I was angry and sad that my mock trial reputation was ruined, but yes.
Miss Becker, I'm not asking how you felt with your mock trial reputation. I'm asking that the first emotion you felt when you got kicked off the team was anger. That's correct, right?
Yes, that's correct.
All right. Let's discuss what your day was like on March 5th. you played video games on your phone at the fry shack, and then you went to the mall and walked all around on March 5th.
Yes, that's correct.
And you claim you lost your phone on March 5th and you didn't notice your phone was missing till March 6th, correct?
Yes, that's correct.
In fact, you ditched school on March 6th to look for your phone.
Yes, I was really worried about where it could be.
And then on March 6th, you looked for your phone the entire day.
Yeah, I was trying to retrace my steps. I mean, going everywhere and looking for your phone isn't an easy job, so it took a long time.
And you were the general size and build as the perpetrator seen in the ring footage.
I have not seen the ring footage.
You're testifying today that you haven't seen the ring footage?
Yeah.
Your Honor, permission, excuse me. Do you remember writing a testimony, Ms. Becker?
Yes.
Your Honor, permission for the witness to view their testimony on my screen?
Yes, you may do so. You may show the statement.
Can you see my screen?
Yes.
This is your testimony?
Yes.
And this is your signature, correct?
Yes, that's correct.
Please read along. Please read in your head as I read 144 to line 145. Blair Rowlands is almost the same size as I am. My lawyer showed me the ring video, and you cannot see the person's face. I get that the person is in the video is my same general size and build. Let the record reflect that I have stopped sharing my screen. All right, Ms. Becker, let's continue with the cross-examination. Excuse me. Taylor Perkins quit the mock trial team so you could get back on A team, correct?
She willingly gave up her spot for me. She thought I deserved it.
And you were, as you put it, best buds with Taylor Perkins?
Yes.
No further questions, Your Honor.
Redirect examination.
No questions, Your Honor.
Thank you for your testimony. The defense's next witness, please.
The defense calls Taylor Perkins to the stand. May you please state your name for the court?
Taylor Perkins.
How do you know Avery Becker?
Avery was my best friend. We both attended Colorado High School together.
Do you know Alex Fuentes?
Yes, I do.
How do you know Alex?
She went to Colorado High School with us.
Are the three of you, Avery and Alex, good friends?
From what I see throughout the years, Avery and Alex were never good friends. So we never hung out outside of that group of mock trial.
Do you consider Alex and Avery good friends?
No, I do not.
Taylor, do you know a fellow student named Blair Rollins?
Yes, I do.
Is Blair associated with Alex Fuentes?
Yes, they are friends.
Objection, Your Honor, lack of personal knowledge.
Response?
Sorry, what was the objection again?
You may state the objection again if you'd like to.
Lack of personal knowledge.
The Taylor Perkins goes to school with Blair Rollins, and she's testifying based on her personal knowledge.
Your Honor, Ms. Perkins, opposing counsel has not laid enough foundation to indicate whether or not Ms. Perkins adequately knew Blair Rowlands enough to testify to his relationships with other students at Colorado High School.
I will overrule the objection. I'll permit cross-examination, of course, on the point.
Taylor, can you tell us where you were and who you were with on the morning of Thursday, March 5th of 2020?
I was with Avery Becker After school, she wanted to talk to the coach, but that didn't end up happening. So we went over to my house to play some video games on our phones.
And where were you in the evening?
I was with Avery Becker at the Fry Shack.
Did you encounter anybody at the Fry Shack?
Yes, we encountered Alex Fuentes.
Did anything happen between Alex and Avery?
Yes, Alex and Avery got in a little bit of a fight that upset Avery, and she ran to the bathroom. She left her phone there, which was really weird because she never leaves her phone. It was like her third company. After she came back, we left, and I do not remember if she grabbed her phone.
So were you with Avery the whole day of March 5th?
Yes, I was.
Can you tell us where you were and who you were with on the morning of Friday, March 6, 2020?
On March 6, 2020, Avery was on her way to pick me up, but she wasn't answering any of my texts. So when she got to my house, we found out that she lost her phone the night before.
So where did you go after realizing this?
We ended up ditching school that day and spending the whole day retracing our steps.
When did you find out about the death of Mackenzie Brackman?
At the end of the day.
And were you with Avery the whole day on March 6th?
Yes, I was.
No further questions, Your Honor.
Cross-examination.
Good afternoon, Ms. Perkins. Let's begin by discussing the defendant. The defendant is your best friend, correct?
That is correct.
The defendant and Mr. Brackman had an ongoing conflict?
That is correct, but although she very much liked the coach, she admired him.
Mr. Brackman upset the defendant?
That is correct.
In response to a particularly heated argument, the defendant vandalized Mr. Brackman's vehicle with a permanent marker?
Yes, although she did think that it was expo marker.
Mr. Brackman then kicked the defendant off the mock trial team?
That is correct.
In an attempt to get back on the team, the defendant texted everyone on the team?
That is that is correct.
Including Alex Fuentes?
I don't know, probably.
After school that Thursday, Mr. Brackman told the defendant to leave after she had tried to convince him to let her back on the team?
That is correct. She wanted to convince him to let him back on the team, and she also wanted to apologize.
But he told her to leave nonetheless?
That is correct.
Mr. Brackman was found dead the very next day?
Yes, that is true.
Let's clear up a few things about the defendant's phone, Ms. Perkins. The defendant had a habit of having her phone with her?
That is correct. It was like her third kidney. She took it everywhere.
After leaving the Fry Shack on March 5th, you weren't sure whether the defendant had grabbed her phone, correct?
Correct.
You went to the mall with the defendant after leaving the Fry Shack?
That is correct.
At no point while at the mall did the defendant appear to realize her phone was missing?
That is correct. We were busy the whole time.
The next morning, the defendant wasn't answering your texts about whether you were going to school together?
That is correct, because she could not find her phone, so she could not answer my text.
You still were able to meet up to go to school together without this communication?
Yes, because she picked me up.
You were the one to point out that the defendant hadn't been using her phone?
Yes, that is correct.
That's when you realized the defendant's phone was missing?
That is correct.
At no point during the night after the defendant left the Fry Shack did she notice that her phone, her third kidney, was missing?
That is correct.
At no point during the morning of March 6th to when she wound up at your house did she notice that her phone, her third kidney, was missing?
She noticed it after she got to my house when I told her I was texting her.
Is that a yes or a no to my question, Ms. Perkins?
That is a yes.
You spent an entire day looking for a phone?
That is correct.
Ditched all your classes?
Correct. We had to retrace all of our steps the day before.
After spending the day going to every single store you had been to the night before, you suddenly remember that the defendant might have left her phone at the Fry Shack?
That is correct. We were retracing all of our steps and realized we went to the Fry Shack the night before.
During your search, you never thought to use iCloud or Find My iPhone to pinpoint the defendant's phone?
That is correct.
Finally, Ms. Perkins, I'd like to talk about your recollection of March 6th and Avery's recollection of March 6th. Your story matches with Avery's?
That is correct.
More specifically, you knew your stories matched when you gave a sworn statement ahead of today's trial?
That is correct.
You mentioned that your stories matched in that sworn statement.
Yes.
No further questions, Your Honor.
Redirect examination.
No, Your Honor.
Thank you for your testimony.
Thank
The
you.
defense's next witness, please.
Defense calls Blake Van Owen to the stand. Good afternoon. Please state your name and spell it for the court.
My name is Blake Van Owen, Vanowen.
Can you explain specifics of your job, Ms. Van Owen?
Yes, I'm a professor, a private investigator, and an expert witness in police practices.
Can you speak to your education?
I have my bachelor's in English from CU Boulder and my master's in criminal justice from Ashford University.
And what qualifications do you have?
I have lectured on police practices and social justice at CU Denver for over 5 years. I was also a police officer from 2005 to 2006. And on over 100 cases, I have served as an expert witness on a very wide variety of topics. I have also worked as a private investigator, a school resource officer, and a private security guard.
As an expert witness in those cases, can you explain a few of the topics?
Yes. The areas of police practices, use of force, false arrest, and forensic evidence. I have also been an expert in crime scene reconstruction, cell tower analysis, and police investigation tactics.
Where have these cases taken place?
These have taken place in the district courts of Colorado, Kansas, and Arizona, and in the state courts of Colorado, Wyoming, Nebraska, and New Mexico.
Can you explain your work through the lens of a defense expert?
I am paid for my services as an independent expert. Prosecution attorneys have access to detectives and crime lab technicians at no cost, and thus they use these law enforcement personnel.
Can you explain your work with this case specifically?
Yes, I was called to review the police report, crime scene reconstruction conducted by Kyle Kuzak, as well as the cell tower reports and exhibits prepared by Detective Markowitz.
Your Honor, pursuant to Rule 702, defense moves to make Professor Van Owen an expert in the following fields: police practices, use of force, false arrests, forensic evidence, crime scene reconstruction, cell tower analysis, and police investigation tactics.
People's position regarding that proposed proffer of expertise. It's people's, I'm not sure if counsel's screen may be frozen. I'm not sure. I think it's Ms. Lowe. Oh, there we go.
Your Honor.
Lowe's now become, I can see your movement now. You were frozen before. Please go right ahead.
Are you asking me if I have any objections to the witness being entered?
Yes, I'm sorry. I was asking whether or not you had any objection to the offer of her as a witness, as an expert witness in those various areas.
My apologies, Your Honor, but when opposing counsel was listing the areas of expertise that they were attempting to enter the witness under, my screen was frozen and I wasn't able to hear her.
If I could just ask counsel to repeat those, please, so Ms. Lowe can then make a response.
Yes, of course. The following fields: police practices, use of force, false arrests, forensic evidence, crime scene reconstruction, cell tower analysis, and police investigation tactics.
Yes, Your Honor. I object to all areas of expertise other than general police practices, as insufficient evidence has been laid to the witness's knowledge, expertise in any of these other areas.
Any response?
Your Honor, my witness has testified to being an expert in all of these fields in over 100 cases in various states and courts. And I think that that is sufficient evidence to be laid as an expert witness in these fields in today's case as well.
Your Honor, if I may respond?
Yes.
The witness never testified as to what areas of expertise they've testified in court as well as they only said that they have some experience with it, but never have gone into what experience they have. They have not testified as to how long they've been doing it. They've not testified as to having any education or as to how long they've been doing these things.
My witness has actually testified to all of those things.
Based on experience and training, the court will find that the witness is qualified as an expert in all areas, except I am not going to qualify her as an expert in the field of false arrest. I'm not certain that that's a proper area for qualification, but in all others, she may give her opinions within those fields of expertise.
Thank you, Your Honor.
You may continue.
In your expert opinion, how did you perceive this investigation?
This investigation was rushed and incomplete. I believe that the police were very negligent in a lot of these areas. So as a result, I've conducted additional research and investigation in areas that I believe were neglected by the police in this case. There are very important things that were missed in this investigation.
Can you elaborate on what you mean by rushed and incomplete?
The police came to an easy conclusion, but easy leaves significant doubt as to who actually committed this crime. And I believe that prosecutors should have gone back from the beginning and restarted this investigation instead of just pushing straight forward to trial.
Did you review the documents that Detective Markowitz and Kyle Kuzak has made in this case?
Yes, I did, and that is where I began my investigation.
Did you reach different conclusions?
Absolutely. I disagree with almost all of the conclusions that they came to.
What is your expert opinion about the scuff marks found by the back door?
The fact is, scuff marks cannot be carbon dated. So by saying that these scuff marks were made on March 6th is completely false. They could have been made 10 years ago. Who really knows? There's no way to carbon date them.
And your expert opinion about the brand of the murder weapon?
Kuzak says that the knife was a different brand than the other knives in the block. However, it was not only a different brand, but it was a different make and model as well, with entirely different style and dimensions.
Your Honor, permission to screen share Exhibit 21.
You may.
Is that visible?
Yes.
I apologize. Professor, can you tell me what this is a picture of?
This is a picture of how I believe the intruder would have held the knife.
What makes you believe this?
This is a very natural way to hold a knife. Certain knife handles, including the murder weapon.
Your Honor, this evidence has not been entered.
Any response, Ms. Butler?
I'm trying to lay foundation to enter this exhibit into evidence, Your Honor.
Very well. I will overrule the objection at this time.
Would you like me to repeat the question, Ms. Van Owen?
Yes, please.
What makes you believe this?
This is a very natural way to hold a knife. Certain knife handles, including the knife at the center of this case, are designed to be held with the user's fingers to be going on one specific side of the handle.
Your Honor, defense moves to enter Exhibit 21 into evidence.
People's position regarding Exhibit 21.
No objections, Your Honor.
21 is received.
Ms. Van Owen, can you explain your doubts for how the knife was held?
Yes, after reviewing the autopsy in this case, I do believe that the intruder was holding the knife as seen in Exhibit 21. When using a knife, such as the one at the center of this case, the user will still hold the knife in an overhead fashion, just as you would in a kitchen setting.
And what are your thoughts on the positioning of the victim relative to the intruder?
The ring video does show that the intruder was not that big, and since the stab wound was at a downward angle, Brackman would have had to be sitting down when the attack occurred behind him.
Let the record reflect, I am no longer screen sharing. What conclusions did you make about the ring notifications on the victim's phone?
I am a Ring user myself, and I do know that you are able to turn notifications on and off. However, Detective Markowitz in his investigation did not cover this, so there is no way of knowing whether or not the notifications were in fact on or off.
Can you explain the difference between GPS tracking and cell tower data?
Cell tower data is not as accurate as GPS data, meaning that cell phones can connect to multiple different cell towers depending on which one has the better signal.
Can you elaborate on the accuracy of call detail records?
Call detail records also are not very accurate. Phones, including the one in this case, will connect to the one with the strongest, might not connect to the nearest cell tower and connect to the one that instead has the strongest signal. And these cell towers do cover a very large area. And with there being dozens of people in the area too, there's just a lot of holes.
Can you explain your discovery about the investigation regarding the cell phone records?
Yes, I saw that the police didn't even look at records relating to Taylor Perkins' phone, which was a very big mistake considering that the two were together for the entire day.
Your Honor, permission to screen share Exhibit 22.
May.
Is that visible, Ms. Van Owen?
Yes.
Professor, do you recognize this audio recording?
Yes, I looked into this as a part of my investigation.
Can you describe what occurs in this audio recording?
This is an audio recording from the official court proceedings of Jonathan Rollins. Rollins shouts, "I'll get you back, Brackman," directed at Mackenzie Brackman, who was the murder victim in this case.
Objection, Your Honor, hearsay.
Response.
Your Honor, per the preliminary matters in this trial, stipulation number 4 asserts that this is a certified recording from an open court proceeding, and therefore pursuant to, pursuant to Rule 803.8, the hearsay exception of public records.
Any further argument in support of the objection?
No, Your Honor.
I will overrule the objection and the exhibit will be received.
Your Honor, would you like me to play the audio recording?
If you wish to, you may.
I'll get you back, Brackman, if it's the last thing I do.
Objection, Your Honor. This evidence has not been entered.
The court did overrule the objection and admitted the exhibit. Was there something else you wanted to say about that?
Yes, my objection was to the witness's statement about the audio recording. My objection was to the witness's statement about Jonathan Rollins' statement, not to the evidence being entered. And I do not believe that opposing counsel ever asked that the evidence do be entered.
And I may have jumped the gun. So, Ms. Butler, your position regarding the exhibit.
I apologize, Your Honor.
No, I think it was my fault. I think I was the one that erred on that, so don't feel concerned. But what would be your position as far as its admission?
As I said, pursuant to Rule 803.8, this is an official court proceeding audio recording, and it is a matter of public record, and therefore is not a matter of hearsay in this case.
Ms. Lowe.
No objections to the evidence being entered.
I will then admit this exhibit.
Would you like me to play it again now that it has officially been entered into evidence, Your Honor?
I don't think that's necessary.
Perfect. Then I will continue. Ms. Van Owen, did you come across any other potential suspects in this case?
Yes, the police completely failed to investigate Blair Rollins, who is the daughter of Jonathan Rollins. And Jonathan Rollins, a few months prior, had been charged with murder. He was convicted and sentenced to life in prison with Brackman as his defense attorney. And as was just played, there is an audio recording of Jonathan Rollins threatening Brackman after the court proceedings. And his daughter, Blair Rollins, was present in the courtroom at that time.
What did you discover about Blair Rollins?
Blair Rollins did attend Colorado High School and graduated last year. However, she seemingly disappeared after graduation. Despite thorough investigation, I have been unable to locate her. Not only this, Blair is the same build and height as Avery Becker. And despite all of this, the police still failed to investigate Blair Rollins. The fact is, her father did get put away for murder. Avery got cut from the team. Which one seems like more of a motive?
And going back to your disagreements on the case, What are your conclusions about Avery Becker's house being located on a major traffic route?
The person with possession of Avery Becker's phone was simply traveling along a different route. There is another route that goes by the same cell towers that connects the victim's house and Blair Rollins' house.
What did you conclude about Blair Rollins?
Blair Rollins and Alex Cifuentes were friends, so it's possible that Cifuentes took Becker's phone and gave it to Blair Rollins, which provided an easy suspect. Blair's attendance record does verify that she was absent from school on that day.
Did you come to any other potential conclusions?
Yes, so say Cifuentes didn't help Blair, but there is a possibility that Blair could have gotten a hold of Avery Becker's phone at the Fry Shack, where multiple witnesses do testify to being on the evening of March 6th, 2020. Blair Rollins very easily could have been there, found Becker's phone, as it is a very popular burger place for students at Colorado High School.
No further questions, Your Honor.
Cross-examination.
Yes, Your Honor. Good afternoon, Professor Van Owen. You're a seasoned expert witness for the defense?
Yes.
In fact, you only testify as an expert witness for the defense.
Yes.
You said you make a decent living revealing where the police dropped the ball?
I do.
You believe yourself to be a check on the power of the police?
Yes, that is correct.
You agree that physical on-scene evidence points to an intruder who broke into the home of the victim, Mackenzie Brackman?
Yes.
And on the note of the cell tower data showed that the phone, Avery Becker's phone, communicated with a tower in the area of Mackenzie Brackman's home.
Yes.
This shows that Avery Becker's phone was near the house at the time of the murder.
Not necessarily. It could have just connected to the cell tower with the best signal.
Just to reconfirm, you're stating that this does not show that Avery Becker's phone was near the house at the time of the murder.
Yes.
Professor Van Owen, do you have your witness affidavit on you today?
Yes, I do.
Does opposing counsel have a copy of the witness's affidavit?
I do.
Ms. Van Owen, in this affidavit, did you sign this affidavit?
Yes, I did.
Did you swear to tell the truth?
Yes.
Were you aware that if anything else came up or if you learned any new evidence, you had to update your witness affidavit?
Yes.
Permission to screen share the witness's affidavit?
You may.
My apologies. Just to reconfirm, this is your signature?
Yes.
I'm going to scroll to line 73, I believe. My apologies. May I stop screen sharing for a minute? Your Honor?
Yes.
Thank you. Okay, I will screen share again. Permission to screen share again?
You may.
I'm going to scroll to line 149. Can you read along with me as I read your affidavit?
Yes.
The records show that Avery Becker's phone was near the house at the time of the murder. Let the record reflect I have stopped screen sharing. Professor Van Owen, you take issue with the prosecution's claim of the intruder being in front of Mr. Brackman.
My apologies, I did end up misspeaking.
To continue on, you take issue with the prosecution's claim of the intruder being in front of Mr. Brackman.
I did say that, however, now looking back, I do not.
You disagree that the victim and the intruder were wrestling for control of the knife?
I do.
You stated that when people grab a knife to stab down, most of them hold it with the blade pointing toward the ground where the knife is.
Yes.
Additionally, for the intruder to stab Brackman in a downward angle and still nick Brackman's aorta, especially if they're both standing, the intruder would have to be much bigger than Brackman.
Yes.
And this, the intruder being larger than Brackman, fits the police narrative.
Yes.
You stated that it would be beneficial for your case to get the defendant's cell tower records from the day before the crime.
Yes.
But you failed to do this.
Yes.
Ms. Van Owen, do you have, my apologies, Professor Van Owen, do you have a copy of Exhibit 10?
I do.
Your Honor, let the record reflect at this time, I am screen sharing what has been entered as Exhibit 10, entered into evidence as Exhibit 10. My apologies. Previously entered into evidence.
Yes, you may screen share.
Let the record reflect that I've stopped screen sharing. Professor Van Owen, do you hear a sound of someone repeatedly pushing a button?
I do.
This button being the doorbell on Brackman's home?
Yes.
Alex Fuentes was friends with Avery Becker?
Yes.
So you believe that my apologies, they were friends with Blair Rowlands?
Yes.
And so because of this, you believe they stole Avery Becker's phone?
Yes.
And framed Avery Becker for murder?
Yes.
No further questions, Your Honor.
Redirect examination.
Yes, Your Honor. Ms. Van Owen, when you were, I apologize, when you were looking at the cell tower data records that were found in this case, you said that the records show Avery Becker's phone was not near the house at the time of the murder. However, did you continue on to say that Avery Becker might not be at the house?
Yes, I did.
No further questions, Your Honor.
Recross examination.
No recross, Your Honor.
Thank you for your testimony. That concludes the presentation of evidence. Let's move to closing arguments. The prosecution reserved any time that might be remaining after their opening closing for a rebuttal closing. So that time is reserved to them, if there is any, after they complete their initial closing. The people's closing argument, please.
You saw Exhibit 14. Well, if he's upset about his car, then he's going to be really upset when he sees what I do to his house. I'm going to wait till he's at work, then break in and trash it. That'll show him. What is seen in this case is a pattern of taking it a step too far. The defendant taking it a step too far, vandalizing Mackenzie Brackman's car. The defendant taking it another step too far, planning to break into Mackenzie Brackman's house. As Becker told you herself, they were on bad terms. Lastly, the defendant taking it a fatal step too far, with this attempted burglary leading to Mackenzie Brackman's tragic death. The defendant didn't mean to kill Mackenzie Brackman, but their action, fueled by their rage of losing their spot on their beloved mock trial team, caused the death of their coach, Mackenzie Brackman. Avery Becker has been charged with second-degree burglary and first-degree murder. In order to have committed second-degree burglary, the defendant must have broken an entrance into Mackenzie Brackman's home, then remained unlawfully to commit a crime of criminal mischief. This crime of criminal mischief being a plan to vandalize Mackenzie Brackman's home. We see an intruder, the same size as the defendant, enter the Brackman residence through ring security videos. We see them break in, first testing the front door for access. When not gaining this access, breaking through using the back door. We see Avery Becker's phone, Avery Becker at Brackman's home, the time of the murder. Becker left his home and then headed towards Brackman's home and was at Brackman's home from 1:05 to 1:15. If Becker's phone was stolen, why would it be at his home? Becker was there at the time of the crime. In order to commit first-degree murder, the charge of second-degree burglary must have been proven. After proving this, the defendant, while committing or attempting to commit second-degree burglary, or in a flight from Mackenzie Brackman's residence, must have caused the death of another person, Mackenzie Brackman, in order to have committed first-degree murder. In this, we see a struggle between Brackman, who armed himself with a knife to defend himself from the intruder. This knife eventually ended in Brackman's back, and once removed, caused Brackman to bleed out and die. The validity of this altercation is Mackenzie Brackman was alerted to the intruder. Mackenzie Brackman had ring security surveillance and was alerted through this. But even if, with Professor Van Owen's theory, was not alerted through ring security footage, you saw Exhibit 10. You saw the intruder repeatedly ring Mackenzie Brackman's doorbell. This would have alerted Mackenzie Brackman to an intruder. We see this struggle and the broken plate and scuff marks. As my co-counsel informed you today, the prosecution has the burden of proof. The burden of proof being proof beyond a reasonable doubt. Reasonable doubt is any doubt that would cause a reasonable person to hesitate in matters of importance. If all of the elements of the prosecution's case must be proven beyond a reasonable doubt. If any piece causes you to hesitate, you must acquit. I agree with the defense. There are questions in this case. There's a question of the defendant's alibi. They were just searching for their phone. But does someone search an entire day, skipping school, without borrowing a phone to use Find My iPhone to locate their phone, their third kidney? There is another question, a question of Alex Fuentes and Blair Rowlands. Alex Fuentes was friends with Blair Rowlands, but it appears highly unlikely that just because someone is friends, they would frame another person of murder. The defense will argue that Blair Rowlands is a suspect because of motive. The defendant also had a motive to vandalize Mackenzie Brackman's home, losing his spot on the mock trial team. You must ask yourself, do actions or a dramatic event prove guilt? Does hard physical evidence link someone to a crime or gossip of another person's connection to the victim prove involvement? The defense asked you to look beyond the defendant's, my apologies. You heard Becker. You heard her testify as what she did before she vandalized Brackman's car. You heard her testify that she told her mother, I will get back at Brackman if it's the last thing I do. Did Blair Rowlands or Becker say that they would get back at Brackman? Becker did. Blair Rowlands did not. That was Blair Rowlands' father who said this. In everything brought before you today, the prosecution asks you to hold the defendant Avery Becker responsible and find her guilty of all charges.
Defense closing argument.
Your Honor, members of the jury, may it please the court. My name is Tatum Butler. I represent the defense in this case. Ladies and gentlemen, this trial comes down to one simple thing. The prosecution wants you to believe that this is a burglary gone wrong, that someone has taken a final step too far. However, you've heard from 6 witnesses today, and you've seen the evidence. This is not a burglary gone wrong, but an investigation gone wrong. You've seen 3 main things today. First, that the prosecution wants you to believe that Avery Becker committed this crime because she appears to have the strongest motive. They claim her feud with Brackman is evidence of her taking a step too far. However, we've shown you that when it comes to motive, Blair Rollins has the much stronger one, as her father, Jonathan Rollins, is serving a life sentence for murder and has expressly blamed Mackenzie Brackman. Not only is Blair Rollins not here today, but the prosecution has failed to investigate her at all, despite her motive and being the same size and build as Avery Becker, both being crucial parts of the prosecution's case. I remind you of the Ring videos, which show an intruder entering Mackenzie Brackman's home on March 6, 2020. This intruder was approximately the same size and build as Avery Becker, but that should also go to show that the intruder was the same size and build as Blair Rollins as well, yet the prosecution hasn't considered Blair as a suspect. Leading to my next point, that's second, the prosecution wants you to believe that Avery Becker committed this crime because of evidence that is circumstantial at best. I remind you of the cell tower data, which places Avery's phone in the general area of the victim's house. However, our expert witness has told you that cell tower data isn't all that accurate. However, if you don't believe that, our expert witness has also asserted that there are other explanations for her phone being in the area at that time, including the possibility of Avery being framed by the true culprit. I also remind you of the text messages in Exhibit 14. There is no proof that these text messages came from Avery Becker at all. Why would Avery have to introduce herself to Alex if they're best friends? Detective Markowitz relied on a teenager to turn in screenshots of evidence instead of asking for the phone itself to pull the messages, which they had the necessary tools to do so. There's no evidence to prove that these messages aren't falsified. Additionally, other evidence such as the scuff marks by the back door. The prosecution asserts that this indicates a struggle, but as explained by our expert witness, there's no way to know when those scuff marks were made and do not themselves point to an intruder, let alone point to Avery. The list goes on. The prosecution's investigation is shaky and far from airtight. The prosecution has claimed that our 3 defense witnesses are unreliable, but even if that were the case, their own witnesses don't seem to be reliable either. We've heard from a detective who trusted a teenager to turn in copies of evidence and didn't think to follow up after said teenager claimed to not have her phone with them during the interview. We've also heard from a certified crime scene reconstruction expert with no expressed education, who, despite being an expert and a certified CSR with 19 years of experience, claims that this case wasn't terribly complicated, yet was still unable to produce a complete reconstruction. We've also heard from the teenager who submitted screenshots of text messages instead of producing the cell phone itself, and claims that he is best friends with the defendant despite the text messages in which Avery introduces herself before beginning the conversation. The prosecution has relied on these witnesses to build their case, but if the witnesses aren't reliable, how are we supposed to trust the credibility and integrity of their case? Which leads me to my last point, that third. The prosecution has the burden of proof in this case to show that Avery Becker has committed this crime beyond a reasonable doubt. That is the legal standard. However, our witnesses and the evidence shows that there is doubt with multiple facets of this case. Jury members, do you have doubts about the scuff marks by the back door, the manner of how the knife was held, according to Kyle Kuzak, the brand of the knife not matching the knife block, the generic evidence of the intruder being roughly the same size as Avery, which also points to Blair Rollins, a viable suspect who was never investigated? These are reasonable doubts, jury members. I have doubts about all of these things. Therefore, members of the jury, I not only implore you to return a verdict in favor of the defense, but I also remind you that you are obligated to return a not guilty verdict because of these doubts. Even if you believe a majority of what the prosecution says, but you have doubts about one thing, that single doubt negates it all. That is your duty, your responsibility. Do not allow an innocent girl to suffer the consequences of the prosecution's failed and shoddy investigation. Because while the prosecution wants you to believe that Avery Becker is simply a good person who's done a bad thing, they have failed to prove that she has done that bad thing. If you have doubts, jury members, which you should, then declare Avery Becker not guilty of all charges. Thank you.
Rebuttal argument from the people.
Your Honor, I believe that I ran out of time.
Oh, okay. Thank you for recognizing that. I wasn't quite clear on what the time was remaining. At this point then, the trial has been concluded. Our scoring panelists, our jury, will be finishing up their score sheets. I would ask that as they finish doing what they need to do in their papers, that they then notify the monitor and that she then makes sure that they appear back on the screen so that they can make comments if they have them. and I'll know that they're finished and ready to make comments. While we're waiting for that to happen, let me just tell all the participants, job well done. We can chat here for a few minutes, and what I'd like to do is just ask that you all give me some feedback about how you think things went. How about Ms. Harriman, having given the first opening, what is the thing that you felt best about today in this first round? What did you feel you did best?
Well, I would say that opening statement, the introduction to the opening statement went much smoother than it has in the past. And I really appreciate that, because when I started my opening statement, I didn't have as many, nerves. And I think that our timekeepers did a fantastic job of alerting us as well.
Okay. Anything that you felt like you'd like to try to do better? Anything that you felt a little bit, here's an improvement I can make?
I think that I should probably work on calming myself down a little bit before I start speaking, rather than focusing on the facts of my opening statement, which is obviously important. I also think that, it's a good thing to, make sure that you're ready to deliver it properly and, most importantly, confidently.
Ms. Duffy, how about you? What did you think you did best today?
I thought I did pretty well with remembering my questions and paying attention to what my opposing counsel was saying. And I would just, my opposing counsel did amazing today. They kept me on my feet. It was a really great round, in my opinion.
Any particular things you felt like you'd like to work on or try to better for the next round?
Yes, definitely the technical aspects, just so I can get an extra 30 seconds or so to my co-counsel for their direct exams or cross exams, and maybe a little bit more fluid with my speaking.
Mr. Kim, how about you? What did you think went best today?
I thought for the most part, like technologically, I think we all did pretty good, considering how in the past it hasn't been over Zoom.
Any particular things you'd like to work on, or that you felt were something to be aware of?
Yeah, I think just like calming myself before like delivering the opening statement. It's really nerve-wracking, so it's hard to focus on the statement itself rather than like the nerves you have. So
Ms. Lowe?
I was pretty happy with my questioning about the ring surveillance and my cross. I added that actually today, and I'm pretty happy about how it went over. I thought it was a little bit risky, but I think it was, I think it paid off. And in terms of things to fix, I think just like everyone, I need to work on my nerves. I think I got a little bit too antsy during my closing, where I kind of lost track of time because I was a little bit nervous.
Okay. Ms. Butler?
I was really happy with how my close went. I was also really impressed by the opponents in this case. As one of my opponents stated, they did definitely keep me on my feet the entire time. That goes for attorneys and witnesses. As far as things that I can fix, nerves, as everybody has stated, and also just maybe taking a little bit more fluent notes. I think that my notes got a little bit jumbled for a little while there, but yeah.
I don't know. I didn't detect a lot of nerves from any of you. I compliment you for your poise. I think we're still waiting for one of our panelists to finish up. So how about Ms. Kennedy? What was your best today?
Yes, I thought that the questioning, I realized that I was pretty calm, but at the beginning I was very nervous, so I was pretty surprised about how the questioning was going.
And do you have anything that you'd like to identify as something to get better at?
As everybody else stated, my nerves.
Okay. All right. Thank you. How about any of our witnesses? Ms. Kite?
I was happy with how our entrance of exhibits 10 through 13 went, since that's something kind of new that we started doing, where Markowitz speaks over the exhibits as they're playing once they've been entered. And I thought that ended up going fairly smoothly. And one thing that I think I should improve is that I realize that when I'm testifying, my eyebrows sort of start to furrow together and then I get a headache afterwards. So I should stop that.
Well, I'd love to hear from the rest of you too, but I see that all of our scoring panelists are ready to comment. And we have been asked to kind of make sure things keep moving along because there's another round coming up. So if I could ask our panelists to contribute anything they'd like to, please do keep your comments down to just 2 or 3 minutes if you can. Ms. Turner?
Sure. Hats off to all these students. I thought they did a wonderful job. And I know you guys said you were nervous. When adults are in the courtroom, they sometimes get nervous. And I would say oftentimes adults are flipping through notes and stumbling through things a lot more than you guys did. So I thought you all presented in a really nice, professional, prepared manner. And that certainly came across. I think as the trial got going, you did better and better. I think you also did better at raising objections and, responding to some of those objections. And so that's, an area that I think improved as it went along, but I thought all of you just did such a nice job for, a young age, young in your learning and interest and potential career in law.
Thank you, Ms. Tanner. I think you're muted still. There we go.
Yes, I would absolutely second Ms. Turner in expressing how impressed I am at the handling of the facts, the fact pattern, and the professionalism in which you were able to handle yourselves today. Nerves are a natural response to trial, be it a witness, an expert, or an attorney. I always tell newbie attorneys when they come in that if you're not feeling nervous, you're not prepared. You have to have some type of nerve in you because you want everything to go right. And I think each one of you were able to exhibit that you were able to take those nerves and turn them into something very positive. I think there are some very bright futures here. I'm very impressed. I think the objections were coming along, as Ms. Turner had indicated later in the trial. So it showed us that you were more comfortable with the flow. I felt that the fluidity in which you spoke was fantastic. Sometimes you can get a little caught up in your words and or on your pages. And although there was a little bit of that going on, you were all able to recover beautifully. So congratulations to you all.
Thank you. Ms. Sennison.
Yes, I echo what everyone has said so far of all these kids. You're not kids, you're young adults, and you are so well prepared and more professional than a lot of lawyers are towards one another and to the court. You showed a lot of respect and maturity in how you addressed the judge in this and the witnesses. I didn't see anybody seem angry towards witnesses, which can commonly happen in cross. And you all had a really great knowledge of the facts. And I was pretty impressed with, cross is so difficult usually because you have to be on the fly to some extent. And I thought you handled that really, really well. I'd say the only comment about trying to improve would be, getting better at getting exhibits in, which is a technical sort of laying foundation for things. But you guys were great, fantastic, and I'm very, very impressed with how you handled yourself, especially with a real judge presiding and other lawyers watching you. So You guys are great.
Thank you, Ms. Sinnison. Ms. Wexler, are we compliant with all the rules? Have we gotten the different scoring sheets to the right people? Are we good?
We have received all the scoring sheets and we are all good on our end.
So at this time, I would be able to recess this proceeding and let everybody leave this courtroom?
Yes, Your Honor.
Okay. Once again, my compliments to all the participants. Well done. I will declare a recess in this particular trial.
Thank you so much. I really appreciate you.